Most people come in to see me and they've been wronged at work. They've either been fired, they've been suspended, they're being harassed, or they're being retaliated against in some way or method in which the terms and conditions of their employment have been adversely affected. Does that mean that that person, because they've been wronged, necessarily has a legally viable cause of action? Can they file a lawsuit? The answer is not always. Sometimes employers are just plain unfair and they've done some pretty awful things to their employees, but that doesn't necessarily mean that the employee has a legally sound basis to file a lawsuit. So what kind of questions am I asking you then as the employee who has been terminated or suspended or who has suffered some adverse employment action? Well, I'm going to tell you first of all that you're an employee at will, unless of course you have a contract, and most state workers, public employees such as police officers, firemen, anybody who works for a municipality or a township, those folks, you folks, are not employees at will. That is, you can't be fired or suspended unless there is good cause. The rest of us are considered employees at will. That is, the employer can take any adverse action against you at their will, so long as that employer is not violating one of your statutory, your common law, or case law rights. What does that mean? Well, there's a whole gambit of rights that we as employees have, and the kinds of cases that we handle here in the Douglas Law Firm are cases that involve the law against discrimination, the New Jersey law against discrimination, and that law protects individual civil rights on the basis of a classification, a protected classification. So although the employer can take any action against you if you're an employee at will, they can't do so if you fit into a protected classification, such as gender or race or military status, for instance. What does that mean? That means that if you believe that your employer is harassing you or who has terminated you because of your gender, or because you are in the military, or because of your disability, or because of your sexual orientation, I would say you may very well have a case. There are other types of rights that you as an employee have besides the New Jersey law against discrimination, such as the Conscientious Employee Protection Act. That law protects individuals who blow the whistle, who report illegal conduct by their employer, and then they suffer adverse employment action because the employer doesn't like the fact that the employee has blown the whistle on their illegal activity, and the employer goes about retaliating against the employee either by a series of adverse employment actions, a series of retaliatory conduct, or just flat out fires the person. And in that instance, I would say, if you as the employee did in fact report or threaten to report an illegal activity by your employer, you may very well have a cause of action. There are constitutional claims that we handle here in the Douglas Law Firm. For instance, the First Amendment is a great source of employee protection. If you as an employee are attempting to organize a union, you have every right to do so under the First Amendment of the United States Constitution. And if your employer doesn't like it and chooses to retaliate it against you, by taking some adverse employment action against you, such as firing you, because you are attempting to organize a union, I then say to you, you may very well have a cause of action. As you can see, there's a whole host of legally recognizable causes of action. But the job that we would have is to determine whether or not your set of facts presents a situation in which the law protects those set of facts, those actions that you took or did not take. And if we determine that the law does or did indeed protect you, then we would, and if we believe you and we believe in your case, we'll take your case. And when we do so, we generally accept cases on what's called a contingency fee basis, meaning that while you would have to pay for costs, expenses, such as the cost associated with filing the complaint or hiring an expert, all of the fees, the hourly fees that we would be generating, all the time that the Douglas Law Firm would be working on your case, would not be charged to you until the end of the case. And that's only if you won the case. You see, and that's why it's important that we believe in your case and that we know that we're operating on sound legal principles. We want to take a case that we know we're going to win for you. And that's part of our analysis process. So when we determine that you have a legally sound case, we'll set out to advise you of all the things you need to gather: witness statements, documents, emails, different pieces of evidence that you will want to secure before we actually file a lawsuit. So if you think that you may have a legally recognizable claim, it's best for you to find out.